name is Tammy Mitchell. I am the Director of the Office of Electric, Gas, and Water at the New York State Department of Public Service. I've been designated to serve as the alternate representing the chair of the New York State Board on Electric Generation Siting and the Environment, or as it is also known, the Siting Board. I call this meeting of the Siting Board to order. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board. Louis Alexander, alternate representing the Commissioner of the Department of Environmental Conservation. Dr. Elizabeth Lewis Michael, alternate representing the Commissioner of the Department of Health. Vincent Ravishir, alternate representing the Commissioner of the New York State Department of Economic Development. And John Williams, alternate representing the Chair of the New York State Energy Research and Development Authority. I would also like to introduce the ad hoc members for Case 19-F-0366, Richard Swinehart and Joseph Wukich. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda.
Thank you, Secretary Phillips. We will begin with Case 19-F-0366, application of Trelina Solar Energy Center, LLC, for a Certificate of Environmental Compatibility and Public Need pursuant to Article 10 to develop, construct, and operate a solar generating facility with a maximum generating capability of 80 megawatts in the town of Waterloo, Seneca County. Presented by Dakin Leakakes, Chief Administrative Law Judge, Department of Public Service. Michael Caruso, Administrative Law Judge, Department of Environmental Conservation, and Brian Osius, Managing Attorney, Department of Public Service, are available for questions. Judge Leakakes, please begin.
Thank you very much. Good morning, Chair Designee Mitchell and members of the Siting Board. Before you is a draft order of the Siting Board that, if adopted, would grant to Trelina Solar Energy Center, LLC, a conditional certificate of environmental compatibility and public need to construct and operate a commercial-scale solar electric generating facility. The Trelina facility would be a solar electric generation facility with a generation capacity of up to 80 megawatts, consisting of commercial-scale arrays of solar photovoltaic panels together with associated facilities. The project will occupy a fenced-in facility area of 418 acres within a 1,067-acre project area in the town of Waterloo, Seneca County, New York. In addition to the solar photovoltaic panels, the project will include inverters, fencing, access roads, collection lines, a laydown staging area, and collection substation and interconnection facilities. To supply electricity to the New York State Bulk Electric Transmission System, the project will interconnect with an existing adjacent 115 kilovolt transmission line owned by the New York State Electric and Gas Corporation. The foundation for the draft order is a robust evidentiary record that supports all of the statutory findings that the Siting Board is required by Article 10 of the Public Service Law to make before issuing a certificate authorizing the project to move forward. The Article 10 review process in this case was extensive, fair, and open, including significant pre-application development during the public involvement plan phase, as well as both the pre-application scoping phase and the evidentiary process that were managed by the administrative law judges Sean Mullaney of the Department of Public Service and Michael Caruso of the Department of Environmental Conservation. In addition to the applicant Trelina, active parties in this case included the Department of Public Service staff, the Department of Environmental Conservation, the Department of Agriculture and Markets, the Department of Health, and the town of Waterloo. Intervenor funding was made available and awarded in both the pre-application and application stages. Notice to the public was provided with respect to all significant milestones in this case. There were many instances of community outreach and education and numerous opportunities for public participation. Trelina carried out a public involvement program which included, among other things, establishing a project-specific website, local document repositories, and a toll-free telephone number for access to project information. In addition, throughout the Article 10 process, the Department of Public Service carried out extensive public outreach and sent notice of all significant project milestones to the parties and service list. The Department of Public Service also hosted public statement hearings and solicited public comments through several other means, including an online comment page on the department's document and matter management website, email and regular mail, and a toll-free phone number. Throughout this proceeding, the department received over 100 public comments through the various means available. There was substantial support for the project. Supporters cited the project's expected economic benefits, such as increased job opportunities and tax benefits, the fact that the project will provide a reliable source of revenues to local municipalities, that participating landowners will receive revenues that will help support family-owned farmlands, and the environmental benefits of solar energy generation, including support for wholesale energy markets and addressing climate change and global warming concerns. Supporters also described solar energy development as preferable to the subdivision and development of existing open spaces for other commercial and/or residential purposes. Comments received in opposition to the project cited a number of concerns, including archaeological impacts, community character, impacts on farmland, wildlife, wetlands, and open spaces, visual resources, and local tourism. Opponents also cited construction-related environmental impacts, destruction of the rural character of the area, the potential for adverse impacts to ground and surface waters, and traffic and noise impacts. The proposed draft order would adopt the comprehensive settlement agreement reached by the parties. This agreement resolved almost all the contested issues raised in litigation, such as all issues raised about the project's potential environmental impacts. The agreements have been incorporated into a number of documents that are attached to the order, such as the proposed certificate conditions, the site engineering and environmental plan guide, and the noise complaint resolution protocol. These documents set forth terms and conditions supporting the Siting Board's grant of an Article 10 certificate. As expressly allowed by Article 10, Trelina has requested that the Siting Board waive certain local laws on the ground that they are unduly burdensome. The proposed order grants the waivers that Trelina has requested. More particularly, there are 3 local laws at issue. Waterloo Zoning Law, Section 134.6.b, sub 4b, which prohibits solar panels exceeding 10 feet in height. Waterloo Zoning Law 134.6.b 3H1, which requires that the facility be decommissioned if it ceases to operate for a period of 6 months or more, and requiring then that full decommissioning and site restoration take place within 30 days. And number 3, Waterloo Zoning Law 134.6.b 3H4, which requires a 20-year decommissioning bond that must be renewed after 15 years for an additional 20 years. The order would waive compliance with the local 10-foot height limit because this law would preclude the use of tracking solar PV panels, which can reach a height of 13 feet at full tilt. In addition to the proposed tracking panels being more efficient, the use of static panels would require a larger project footprint to achieve the proposed facility's 80-megawatt planned capacity output. A waiver of this local law is justified because the 10-foot height limit is a technological limitation that would increase the environmental impacts of the project. The proposed order includes a finding that compliance with the 10-foot height limit would be unreasonably burdensome, preventing the Siting Board from minimizing the project's environmental impacts to the maximum extent practicable. This finding is consistent with previous Siting Board decisions. For example, in Case 97-F-1683, the Siting Board waived a zoning restriction when granting a certificate to Athens Generating Company because it found there that the existing state of technology required a project component to be located in a manner which local zoning prohibited. Similarly, here the existing state of technology allowing the use of photovoltaic panels that can track the sun's daily movement across the sky to produce the output required to minimize the project's environmental footprint exceeds the local law's height restriction by a relatively small amount and only for a limited time each day. On balance, the grant of this waiver is fair and is justified by the record in this case. The proposed order would also waive compliance with the local requirements for project decommissioning and site restoration. The evidentiary record demonstrates that reasonable and responsible project decommissioning and site restoration will take approximately 5 months, a time period longer than 30 days allowed under the local law. As for financial assurances, Certificate Condition 57 will require Trelina to provide financial assurance in the form of a letter of credit to be held by and for the benefit of the town of Waterloo. The certificate conditions governing financial assurance for decommissioning and site restoration are reasonable, are supported by DPS staff, and are consistent with the past decisions of the Siting Board. The Board's decommissioning precedent dates back to the Siting Board's first Article 10 decision on renewables in Cassadaga Wind. There, the Board expressed its strong interest in protecting communities in which renewable generating projects were being built by providing conditions on project construction and operation, including strong financial protections that would ensure any Article 10 project could be decommissioned and the site restored timely, responsibly, and safely, regardless of the solvency of the project owner at the time of decommissioning. In summary, the record supports a finding by the Board that the probable environmental impacts of the construction and operation of the facility will be minimized or avoided to the maximum extent practicable, provided that the applicant complies with the certificate conditions. The record also supports a finding by the Board that the facility is designed to operate in compliance with all applicable state and local environmental, health, and safety law and regulations that are not otherwise waived. The proposed order finds that the construction and operation of the project will serve the public interest because the project will be consistent with state energy policies, long-range energy planning objectives, the strategy set forth in the most recent state energy plan, and the additional social, economic, and other factors deemed relevant by the Board. On behalf of the examiners in this case, Sean Mullaney and Michael S. Caruso, I endorse the proposed draft order and recommend that the Siting Board adopt it. Thank you.
Thank you very much, Judge Leakakes, for your comprehensive summary of this item before us. I believe the proposed draft order is well balanced, mitigates impacts to the extent practicable, and flows from a robust public process. I will be supporting this item. Let me turn to my fellow board members for any comments or questions. Mr. Alexander.
Thank you. I have two comments with respect to this matter. The first relates to environmental justice issues. The order indicates that applicant did not strictly comply with all the requirements of 6 NYCRR Part 487 regarding environmental justice. However, I see that DPS staff reviewed the environmental justice issues here and determined that the construction and operation of the facility is not expected to have environmental justice impacts. And I think this underscores how in these Article 10 proceedings, DPS staff as well as DEC staff undertake significant analysis in evaluating project-related issues. Staff efforts have here, as well as the work of the DPS and DEC hearings offices, the work has been thoughtful and thorough and is much appreciated. My second comment relates to solar glare. I understand the conclusions here as to solar glare impacts related to this project. However, it is evident that this issue will continue to be important as we look at solar project proposals in the future. I have no further comments at this time. Thank you.
Thank you. Dr. Lewis Michael.
No comments or questions.
Thank you. Mr. Ravishir.
I have no comments or questions.
Thank you. Mr. Williams.
No comments or questions.
Mr. Swinehart.
No comments, no questions.
And Mr. Wukich.
I have a comment and possibly follow up by a question. I'm referring to a document that was sent to me on November 4th by Michelle, where it deals with the SEEP, Visual Mitigation, Landscaping, and Buffers. Specifically page 9 and Going over to 10, it indicates the responsibility of the applicant, the location, and I'm reading from the document itself, the location of visual mitigation planting areas and specific planting modules proposed will be shown on the site plans. The landscape screening plan will include the species composition, planting plans, and specification for each of the mitigation modules. Location of existing vegetation to be retained as visual screening with specification of protection measures to avoid construction damages and retain such vegetation. To follow up, documents number 101 and 102 have photographic evidence to support the existing vegetation. However, in the 300 and I believe 20 separate documents in the DPS on the DPS website, there is no landscape screening plan that could be found, particularly as it pertains to what type of species, etc., that might be used as part of the visual screening. At this point, I would entertain any type of conversation relating to this being one of the checkoff boxes that was a requirement for the licensing to proceed. Thank you.
So this is Chief Judge Lee Cakes, and I'll take the first attempt at answering your question and then defer to Brian Osius, the managing attorney, afterwards if I miss anything. But the certificate condition that you read does require that those elements be laid out prior to construction beginning on the project. But the way that those plans are developed they are developed post-certificate and then filed with the siting board as a compliance filing. When those are filed, the siting board, or if the siting board's jurisdiction has expired at that point, then the Public Service Commission takes over, reviews those plans, and will take any comments that are filed on those plans from the general public in determining whether to approve them as being compliant with what the certificate conditions required or not. So the fact that the elements of that plan don't exist in the DMM system at this point is explained by the fact that that has not been developed yet, but it is supposed to be developed by the applicant prior to project construction beginning.
No, I think that's correct. And again, just to emphasize, there is a public comment period, and DPS staff as well as DEC staff will be consulted in advising either the siting board or the commission on whether or not to approve the compliance filing as filed, or it requires additional supplement or conditions for compliance.
So do we meet again?
So if I understand what you're saying correctly, are you saying that we would meet again relative to this issue before the license is issued?
So the license is being issued in the form of a certificate today, but there are several different compliance filings that are needed before certain phases of construction begins. And this compliance filing would be required certainly before operation of the solar plant. And whether or not the siting board will meet to vote on that compliance filing, or the Public Service Commission would meet to vote on that compliance filing, turns on whether or not the siting board's jurisdiction has ceased. And the way that works under the Public Service Law is that the siting board's jurisdiction remains intact until the period for an appeal has run. And I believe under the Public Service Law, Article 10, that is 30 days. Am I correct, Aiken?
Yeah, that is correct. And if an appeal is filed, then the siting board's jurisdiction remains in place while the appeal is pending and until there is actually a siting board decision on that appeal. So if the siting board takes some extra time to consider whatever appeal is filed, the siting board's jurisdiction over the project continues during that entire time.
And if there's no appeal, then the siting board's jurisdiction will cease for purposes of compliance filing approval, and it will turn to the Public Service Commission. But again, there is a public comment period on all of the compliance filings. The siting board, just as an aside, the siting board does retain permanent jurisdiction over things like amendments to the certificate. That would stay with the siting board. But that stays with the permanent board and would not involve the ad hocs.
Well, the other issue that I'd like to bring forward is document number 60. It deals with an environmental statement. Presumably, there's an eagle's nest. The entire document, for the most part, was completely redacted. I can understand redaction if it's going to name people and it's going to name proprietary information that may be impacted in a negative way. Why would an environmental statement involving an eagle's nest be completely redacted for public review? And is that your purview in terms of allowing a redaction to occur?
So I'll turn to Michael Caruso, the DEC Administrative Law Judge. The requirements for the filings and the redactions on endangered species come out of the environmental conservation law and the federal laws concerning wildlife. Judge Caruso?
Yes, thank you, Judge Lee Gates. Anytime that an applicant submits information about the locations of endangered species, nesting, habitat, things of that nature, those locations need to be redacted so that, the department doesn't have the general public going out there, disturbing the nests, etc. So, that's why there's provisions in the certificate conditions that, they can't perform any construction with certain distances from that protected species. So this is really to protect the species, and that's why it's redacted. That's the short answer.
Well, thank you for the short answer. And one last point I was asked to bring forward was there was a survey done of contiguous landowners, residents. These are people whose backyards will abut this project. They will have the glare from the solar panels. They will, in all probability, based upon studies that have been done in Rhode Island and Massachusetts, will suffer reduced property values. To that end, a survey was conducted, and over 98%, almost 99%, of the residents in the impact area as defined by Trelina are adamantly against this project for the cited reasons. The results of the survey are contained in, I think it was number 20-something of the 320 documents on the DPS website. That's a consideration other than just a checkoff box that should be considered for those residents who will have that impact that they have to live with. Thank you.
Thank you. I will now call for a vote. My own vote is in favor of the recommendations as described. Mr. Alexander, how do you vote?
I vote in favor.
Dr. Lewis Michael?
In favor.
Mr. Ravishir? Mr. Ravishir?
Mr. Ravishir, your mic might not be on.
Yes, we'll come back. Mr. Williams,
In favor.
Mr. Swinehart,
In favor.
Mr. Wukich.
Against.
Thank you. Mr. Ravishir, how do you vote?
I'm sorry. Let's take a brief recess to see if we can see why he's not able to respond.
Okay, we are in recess.
So let's go back on the record, please.
I'm sorry, I had some difficulty getting off of mute. I had to quit the program and sign back in. So I
Thank you.
apologize, but I'm back on.
And we are back on the record. Mr. Ravishir, how do you vote?
In favor.
Thank you. The order is approved and the recommendations are adopted. Next is case 17-F-0597, application of High River Energy Center LLC for a certificate of environmental compatibility and public need pursuant to Article 10 of the Public Service Law for construction of a solar electric generating facility located in the town of Florida, Montgomery County. Presented by Norina Chowdhury, Assistant Counsel, Department of Public Service. Brian Osius, Managing Attorney, Department of Public Service, and Corey Strube, Utility Supervisor, Environmental, Office of Electric, Gas, and Water, are available for questions. Ms. Chaudhry, please begin.
Good morning, Chair Designee Mitchell and board members. Before you today is an order granting a petition for amendment of the board's March 11th, 2021 order granting a certificate of environmental compatibility and public need with conditions to High River Energy Center LLC. The certificate authorized High River to construct and operate in the town of Florida, Montgomery County, a solar electric generating facility having a nameplate capacity of up to 90 megawatts, including utility-scale arrays of solar voltaic panels, together with associated collection lines, inverters, fencing, access roads, laydown and staging areas, collection substation, and interconnection facilities. On October 1st, 2021, High River filed a petition for amendment requesting that the Siting Board revise Certificate Condition 69 and Site Engineering and Environmental Plan Guide Section B17, both related to permanent access road stream crossing requirements. Under current Certificate Condition 69A, if culverts are utilized for any permanent access road stream crossing, High River is required to design the culvert pipes to safely pass the 1% annual chance storm event. The amendment petition seeks flexibility to design the stream crossings rather than the culvert pipes to safely pass the 1% annual chance storm event. High River explained that while the certificate order requires culvert pipes designed to pass a 1% annual chance storm event, several stream crossings within the project's limits of disturbance would not themselves withstand a 100-year storm. High River further asserted that allowing it to utilize smaller culvert pipes would result in disturbances to a smaller portion of each stream and require use of less adjacent area to each stream during construction, as compared with the certificated facility. The Secretary of the Siting Board consulted with the staff of the Department of Public Service and the Department of Environmental Conservation before issuing an October 15, 2021 letter concluding that the proposed modification would not result in a significant adverse increase to environmental impacts as compared to the certificated project. Therefore, the modification did not constitute a revision that would require a hearing under the regulations. On November 18, 2021, High River filed a supplement to the amendment petition. The amendment supplement noted that subsequent to the initial amendment petition, High River consulted with DPS and DEC staff regarding wording refinements. The amendment supplement requests that the Siting Board authorize revisions to Certificate Condition 69A to allow the stream crossings to be designed for the 1% annual chance storm event, and requests the addition of a subpart in Steep Guide Section B17 listing the specific stream crossings. The Secretary's letter included a thorough review and addressed potential impacts of the proposed change for the project. As noted in the Secretary's October 15th letter, based on the record of this proceeding, the specific language used to implement the amendment will not affect the environmental impact for this facility. As summarized in the order before you, the proposed change will not result in a significant adverse increase to environmental impacts as compared to the certificated project, and the requested design change will provide environmental and infrastructure protections comparable to the certificated project. Further, given the site-specific considerations emphasized by both DEC and DPS staff, the amendment supplement language is appropriate to implement the changes to allow High River to utilize stream crossings designed to safely pass the 1% annual chance storm event. Accordingly, the draft order before you approves the petition for amendment as supplemented by the amendment supplement. This approval does not relieve High River of the need to comply with the terms, conditions, limitations, or modifications of the construction and operation of the facility authorized in the certificate. That concludes my presentation, and we're available for any questions you might have. Thank you.
Thank you, Ms. Chaudhry. I have no comments or questions on this item. Let me now turn to my fellow board members for any comments or questions. Mr. Alexander?
I have no comments or questions. Thank you.
Thank you. Dr. Lewis Michael?
No comments or questions.
Thank you. Mr. Ravishir?
No comments or questions, thank you.
Thank you. Mr. Williams?
No comments or questions.
Thank you. I will now call for a vote. My own vote is in favor of the recommendation as described. Mr. Alexander, how do you vote?
I vote in favor.
Dr. Lewis Michael?
In favor.
Mr. Ravishir?
In favor.
Mr. Williams?
In favor.
The order is approved and the recommendation is adopted. Secretary Phillips, is there anything further to come before us today?
There's nothing further.
Thank you. We are adjourned.